Welcome, everyone, and thank you for joining us for a presentation today on preparing estate planning attorneys for the Corporate Transparency Act. My name is Jamie Rowley. I'm the Director of Fiduciary Services at Peak Trust Company. Peak is a full-service trust company that offers comprehensive trust administration for attorneys that want reliable and accessible expertise to help them with their clients' complex trust plans. Before we get started, I would like to take care of a few housekeeping items. Today's presentation is being recorded and will be sent out to all attendees. On the right-hand side of your screen, you may enter any questions you have into the Zoom panel, and we will address as many questions at the end of the presentation. Today, we are very fortunate to be joined by attorney Chris Lauer. He is an associate attorney at Manley Broadegum here in Anchorage, Alaska. His practice centers on wills, trusts, and estate planning, wealth protection, tax planning, and forming business organizations. Chris graduated summa cum laude from the Case Western Reserve University School of Law, where he was the Hugo Grotius Fellow. In addition to serving as an executive editor of the Case Western Reserve Law Review, Chris worked as an extern to the Honorable Karen Nelson Moore of the United States of Appeals for the Sixth Circuit. Before law school, Chris worked as a consultant focused on anti-money laundering compliance in the banking industry. Through his work with financial institutions, Chris has firsthand experience with the ways banks attempt and often struggle to implement seemingly straightforward anti-money laundering plans. He has presented extensively on the Corporate Transparency Act and has written critically about the policy design and negative externalities of state and federal anti-money laundering requirements. I am very excited for this presentation today. So Chris, I turn it over to you and let us know if there's any questions in the chat box. Thank you.
Well, thank you so much, Jamie. I really appreciate the introduction and for hosting me. Thank you to Peak for putting this on, and thank you to all of the attendees for being here today. I just wanted to get this out of the way first. Obviously, we've got a disclaimer. The area around this changes a lot. We have very poor guidance from FinCEN, so what's true today might not be true tomorrow. We're hoping to see more clarity and more guidance from FinCEN as implementation rolls out next year. But frankly, it does not feel like estate planners have been a primary focus of the people drafting this legislation, drafting regulations, or implementing them. So we're going to see a lot of movement there, I think. So today I'm going to try to cover a handful of things. There's a lot in this presentation. I'm going to try to get through it in a timely way so that we can answer your questions. My primary goal here is to get through what the Corporate Transparency Act is, what the requirements are, what the penalties might be. I'm also going to talk with you about some of the ways the CTA intersects with estate planning. I'm going to refer to the Corporate Transparency Act throughout as the CTA. We're also going to talk about the ways that law firms and other advisors can plan to implement policies to make sure that we're not getting our clients into more trouble by doing things like LLC-based planning or trust-based planning. So the Corporate Transparency Act has been on the books since the beginning of 2021. It was passed as a relatively small part of the National Defense Authorization Act. And it ended up in that act because really it has an intersection with national defense. This is anti-money laundering policy written into law. The overall goal here is to require most companies to report beneficial ownership information to the Financial Crimes Enforcement Network, or FinCEN. FinCEN is Treasury's enforcement wing. They primarily, historically, have done a lot in the realm of anti-money laundering and financial crimes enforcement, which often wraps up with things like counterfinancing of terrorism or anti-money laundering protocols generally. So a lot of financial institutions, banks, casinos, the like, report raw data to FinCEN, and then FinCEN figures out what to do with it from there. So the overall goal here is to create a database that federal law enforcement, local law enforcement, state law enforcement agencies, and financial institutions can use to coordinate around and identify people who are behind reporting companies. And the purpose behind this is to make shell companies less valuable to money launderers. Shell companies, as a concept, we create shell companies as estate planners all the time. They're value neutral. These are companies that exist with no real physical operating presence, right? A shell company holds an interest in an LLC or an interest in a piece of artwork, but it doesn't have actual on-the-ground operations. So the overall goal here was to say, we want to know who's behind these shell companies. It might be normal everyday people, but it might be very bad people that we'd like to know more about. That's the basis for the Corporate Transparency Act. So what does the Corporate Transparency Act do? It creates new reporting requirements for most companies that do any sort of work in the United States. So if you're a foreign company registered in the US, then you're going to have to report. If you're an entity formed in Alaska or Nevada or Delaware or anywhere else, you're going to have to report. I'm going to discuss primarily companies formed in the United States because the rules are fairly similar for companies that are formed abroad that operate here. And I think it will get very clunky and cumbersome to try and cover all those bases in a talk. So we've already talked about some of the goals. States have various laws on privacy. I don't like the phrase race to the bottom because I think privacy is generally a very good thing, but it makes it somewhat less valuable for someone to create an LLC in a place like Wyoming or New Mexico, where they do not have to report identifying information on the people who actually own the business to the state. Now they have to report that information to the federal government. It's also going to shift some compliance costs and some concerns away from financial institutions onto individuals who are behind businesses. This information is supposed to be stored on a secure federal database. I leave it to you to decide how secure federal centralized databases will be over the long term. This is going to be something that's centralized. We don't actually have good, clean rules yet, we're supposed to, on who is going to be able to access the information that's stored on this system. It's supposed to be law enforcement. It's supposed to be financial institutions. The particularities of that have not yet been ironed out through rulemaking, and they're supposed to be. So, who needs to report under the Corporate Transparency Act? Well, really, there are three types of things, three categories of entities that I guess are nouns really that the corporate that FinCEN wants us to report on to comply with the CTA. We've got reporting companies, we've got beneficial owners, which is actually a much broader term than it sounds, and company applicants. Let's walk through what those are really quick. A reporting company in general, any corporation, LLC, or other similar entity formed by filing a document with a state secretary of state or similar entity is a reporting company. The same goes for any foreign entity required to register in the US. Now, that's a pretty general rule. There are some exceptions to that. There's some just definitional exclusions. General partnerships, sole proprietorships, those are not companies under the Corporate Transparency Act because you don't have to file paperwork with the state for them to exist. Okay, I'm being told that I'm not being loud enough. Is that better? I guess you'll let me know. I'll also try to talk a little bit louder. So general partnerships and sole proprietorships are not companies because you don't file paperwork with anyone for them to exist. That's not to say that you couldn't have a general partnership agreement, but the existence of the entity is not conditioned on filing that paperwork with the state. I'm remembering back to my second year law school business associations course, where my professor insisted that friends don't let friends operate as general partners. It's just difficult to do that. I realize there are some circumstances where that's an okay deal. It avoids reporting because you're not a reporting company. Trusts and estates are also generally not companies for the purpose of the Corporate Transparency Act. There are certain types of trusts, certain business trusts like Massachusetts trusts or Delaware trusts that do require formation by filing paperwork with the state, and those would be deemed to be reporting companies. There are also 23 exclusions, companies that do not need to report. Most of these are for businesses that already have a lot of reporting requirements. a lot of different flavors of financial institutions and brokerage firms and the like. We're also looking at things like that have significant state reporting requirements, like insurance companies. We might have accounting firms that are subject to Sarbanes-Oxley, tax-exempt entities under Section 501c, as long as they have their status, are going to remain excluded from the definition of reporting companies. We're also going to see large operating companies, which is defined as having more than $5 million in gross receipts for the most recent tax year, more than 20, so 21 plus full-time employees in the United States, and a physical operating presence in the US. The reason for that exemption is basically to say, we don't think that you're a shell company. We think that you're big enough to be a real bona fide full-fledged company. And that's, if you're laundering money, that's going to be a separate concern that we'll try to pick up somewhere else. But you've got simply too many irons in the fire, too many employees who could really let the beans spill if you're a large operating company. Similarly, wholly owned subsidiaries of most tax-exempt entities also are not going to need to report. That's a really short summary of them. There are 23 exclusions. I encourage you to look at the actual rule to find all of them because they're going to be construed narrowly. So if you think someone's exempt, really double check. The next item here is going to be beneficial owners. Beneficial owner really means someone who controls the company in some way or another, exercises a degree of control. So it's better to think of these as control persons than as owners, because as you'll see from the definition, ownership doesn't really line up with what they're asking for. Obviously, anyone who owns or controls 25% or more of a company's ownership interest is going to be is going to be treated as a beneficial owner. That's going to be, in most cases, pretty easy to identify. But also anyone who exercises substantial control over a reporting company is going to count. So we're looking at things like senior officers or people who wield the types of power that senior officers have, right? It doesn't matter whether you have a CEO or a junior in charge boy who just happens to be the CEO of the company. They're going to look at what the actual duties are of the person. It's not clear what the line is between senior officers who have to report as beneficial owners and employees who only have control over the company by virtue of their employment. So my office manager can't dictate what my law firm does in any meaningful sense. She's not going to be a senior officer, but in some cases it might blur a little bit. Anyone who can appoint or remove a senior officer, if you've got, if you're really in charge of them, you can dictate what their actions are, right? Presuming they want to keep their job, they're going to try to keep the person in charge happy. And the Corporate Transparency Act reflects that by forcing those types of people to report their information as well. So anyone who can decide important matters over the company is also going to be a substantial control person and therefore be a beneficial owner. That sounds relatively straightforward. The other people who are going to have to apply comply are company applicants. That's people like attorneys who form companies. Anyone who forms a company is going to have their information included on initial reports, and that's those are relatively it's typically only two people. It's actually no more than two people can be company applicants. It's the person who physically files the application to form the company, and the person who directs the filing. The person who directs the filing is not everyone at the law firm. It's not all the shareholders. It is simply the lawyer who says, "You, my paralegal, please form this entity." Those two people have to report their information. You cannot avoid being treated as a beneficial owner by using a trust. Trustees or persons who have authority to dispose of trust assets, they are going to be beneficial owners. This is going to vary a lot from document to document. It's going to look at the facts of a particular case. But under, say, the trifurcated model where you have investment trustees, distribution trustees, and administrative trustees, there's no question that investment trustee is going to be a beneficial owner because they can decide to get rid of the company. A distribution trustee will also, I think, likely be a reporting person as well. An administrative trustee who doesn't have the authority to liquidate trust assets or shift ownership interests, they're probably not going to be a beneficial owner. We're also going to include beneficiaries who are the sole permissible recipients of income and principal. or anyone who may demand distributions or withdraw substantially all trust assets. So for revocable trusts, grantors are going to be controlling persons during their lifetime in capacity. For irrevocable trusts, people who hold swap powers to transfer assets into and out of the trust to qualify that trust for grantor trust status, well, that's a way to shift ownership interests from one place to another. I think it's likely that FinCEN is also going to treat things like swap powers as as an interest that qualifies someone as a beneficial owner. So these are some of the pitfalls and traps that we're going to be walking through. I'm going to talk through those in somewhat greater detail soon. The information that people are going to be required to report doesn't seem all that onerous. The bigger trick is figuring out who needs to report what and when. I will also note too that this is kind of out of keeping with what people have historically needed to report. This doesn't loop in very cleanly with things like income tax filings that everyone realizes they have to do on at least an annual basis. This is something that only comes up when a change in the entity or a change in its beneficial ownership occurs. People haven't had to think about that historically. Normally, they file updated biennial reports or whatever your state requires when ownership changes, but they're not thinking about every person who could possibly exercise control over the entity directly or indirectly. The information that they're going to be required to provide for individuals will be a full legal name, date of birth, a current residential street address, and a unique identifying number. So think of a driver's license or a valid passport, and also a picture of that identifying document. I don't know about you all. My clients don't feel that bad about giving me their social security number, but I've not historically had to ask too many people for their passports. Or their driver's licenses. This may be something that people are uncomfortable doing. Reporting companies, will also need to provide to FinCEN their full legal name, all trade or doing business as names, any business street address. You can't rely on your registered agent's address or the address of your attorney. It's got to be your primary business address. Jurisdictions of formation, and so you'll provide things like the certificate of formation or whatever your state calls it, and then a tax ID number. For entities that are sort of single member entities that typically rely on their owners, on their owner's tax ID number, FinCEN may require a separate identification number for that company. That's still being clarified. I know this doesn't sound so bad, right? The information isn't terribly secretive. There's not that much detail in there, but it can really be a problem. It's easy to get this wrong by misidentifying beneficial owners or failing to file updated reports when necessary. It also undermines everyone's privacy who's involved in business operations, right? You end up in a circumstance where you may have to share private personal information with the people you work with, or with the people who at the federal government who are going to need the information anyway. The costs, I think, for any individual business owner are pretty significant relative to law enforcement benefits. FinCEN estimates that most simple entities will take about 90 minutes to file their first report, but for complicated entities with difficult trust ownership structures, this can actually take many hours of time, some of which may require an attorney's assistance. It can become really, really difficult. And so what benefit does law enforcement really get from being able to say that Acme LLC is theoretically controlled by these people? I'm not entirely sure. It seems like it's pretty broad. It also doesn't tie in with normal business practices, right? It's going to need to be incorporated into the ways people think about their business, and incorporated into things like bylaws and operating agreements and trust instruments and estate planning documents to confirm that any change that happens gets timely reported so no one gets in trouble. I also think that the responsibilities here don't really line up with who's got the best access to information. Reporting companies, by default, are going to be on the hook for getting correct information from beneficial owners. Now, I say generally here, and I've got asterisks on the slide, because there is an alternative way. And this is probably what most of us will do most of the time, and what most of our documents will require people to report. and obtain. FinCEN identifiers are the alternative here. So what these allow, they exist for individuals and for reporting companies. They can obtain FinCEN identifier numbers that provide information to FinCEN. So in exchange for me giving all of my information to the Financial Crimes Enforcement Network, they will give me a short number, a PIN number essentially, that is unique to me. So I can just give my name and that PIN number to shareholders at a firm that I'm a partner in. And that's all they get from me. They don't get my home address. They don't get a copy of my driver's license necessarily. But that I give that to them, and then they can report that information. They will always know that my name and my FinCEN identifier are correct, but it shifts the responsibility from the company to report my home address to me. So if I move across the street, I have 30 days to file updated paperwork with FinCEN. I realize I haven't covered the dates yet. We're going to get to that pretty soon. This is probably a good idea because it's going to shift the risk from companies to individuals to provide information. It's going to we're going to require more from beneficial owners than from the reporting company, which I think makes sense. A beneficial owner is going to know if they're changing their name based on a marriage or a whim, then the company will. And this is going to just allow that process to be more streamlined. It will also, for people who are, say, famous or have a lot of clout, it will allow them to maintain a greater degree of privacy from the people they're involved in business with. Probably a good thing. But there are also, in the estate planning world, we do planning for a lot of people who are not particularly sophisticated, or for people who will eventually become incapacitated. So if I get moved from my house to a nursing care facility, am I really going to be capable of making sure that my FinCEN identifier is updated? Is my healthcare agent under an advanced healthcare directive going to know that they have to provide this paperwork or update this information with FinCEN because my revocable trust document requires it? I don't know that they will. For some people, it might not be advisable as a result of that. Entity identifiers are a little bit different. Reporting companies can provide another entity's FinCEN identifier and full legal name instead of giving complete information, but only if 3 conditions are met. So obviously they've got to provide information initially and get FinCEN identifiers. They have to, we need an individual who may be a beneficial owner of the reporting company because they own the company, who also holds an interest through that holding company. To be a beneficial owner. And then we're also going to need all of the beneficial owners of both the owning entity and the underlying reporting company to be the same individuals. I don't know how useful these are going to be. Theoretically, they might make reporting a little bit easier for companies that have a sort of holding company structure and have numerous fully owned subsidiaries. But in general, wholly owned subsidiaries of reporting companies will typically be exempt from reporting. So we might also have circumstances where a subsidiary entity under a family holding company or other type of holding company may have a separate manager, right? Maybe a child is going to be entrusted with the responsibility to run, the widget making factory, but they're not going to be a trustee or in charge of mom and dad's estate plan. In that case, I don't think you'd be able to provide the entity identifier in lieu of the underlying information. There's going to be rare circumstances where these might be appropriate. I think they're going to be way less useful than getting identifiers for natural persons. So what do you have to do? If you have an existing business, do you need to report? Yes, you do. If the entity exists on January 1, 2024, you have a reporting obligation. So you ask yourself, is the business a corporation, LLC, limited partnership, limited liability partnership, whatever flavor they come in your jurisdiction? Was it created by filing paperwork with a state government? And if it is, does an exception apply? And so you can look through those exceptions and see what really applies. In most circumstances, we're either going to see things like insurance producers and CPAs who are working with, or we're going to see large operating businesses. There's an exception for inactive entities, but that is a very narrow exception. I would not expect most things that we would consider inactive to qualify under the inactive business. It won't cover passive holding companies. It basically just covers companies that are not administratively dissolved. So, assuming the business is created by filing paperwork with the state and no exception applies, then the company needs to report. Companies that exist in 2023 will have until January 1 of 2025 to file their reports. So you've got all year next year to get your ducks in a row and file initial reports with FinCEN. Now, if you're thinking, why don't I simply file now? You're not allowed to. FinCEN has not made that form public and will not make that form online public until January 1 this coming year. Sorry for the proactive people among you. It's still okay to collect client information and be prepared to file if that's something that your firm feels like it can do, but the window for that's getting pretty short now that we're in December. Companies formed during 2024 will have 90 days to file initial ownership reports. And that's reflective of a sort of an onboarding policy so that people have more time to sort of learn what their obligations are and file appropriately. Companies formed in or after 2025 only get 30 days to file those initial reports. After an initial report is filed, companies are required to file updated reports within 30 days of change in any beneficial owner information or any company information. Now, there's kind of an open question. I think there's a clear answer, but I've talked to some people who are less confident that whether existing companies that exist in 2023 or before can fix their ownership. They can make changes before an initial report is filed. The language of the statute and the language of the underlying regulation requires anyone who has previously filed information with FinCEN to file an updated report within 30 days. I think if I have not filed an initial report with FinCEN, that I probably have until I filed an initial report to do any kind of reporting. This is perhaps a tool that will allow us as practitioners to get into 2024 and make sure that our clients can streamline things, they can fix things without triggering difficult reporting requirements or needing to scramble as a result of normal everyday estate planning changes and issues. I will also note that if a company was formed, it was formed before January 1, 2024, company applicant information does not need to be disclosed. You do not need to go back and find a paralegal who worked at your office 30 years ago who may very well not be alive to confirm that to confirm their current address. That's silly. We don't require it to be done. We also don't require any updated information be filed on company applicants, because a person who creates a company is not necessarily going to have more information about the company down the road, but this may theoretically help law enforcement identify law firms that are acting very unscrupulously in forming companies. If we find that a lot of money launderers are using the same law firm, that may spur FinCEN to look more closely at them or have other law enforcement look at them. If you file incorrect information, you've got 90 days to fix the incorrect report. And there's no exception for good faith bad filings. You just got 90 days, otherwise the penalties start accruing. This runs from either when the inaccuracy was filed or when you should have discovered it, whichever is earlier. I'm not really sure what the delta is going to be there. Reporting companies need to file, they're responsible for filing accurate information, and senior officers can be liable. LLC managers, CEOs, CFOs, the like, as can anyone who caused the company to file false or fraudulent information. So if a beneficial owner provides bad information to the reporting company, then the senior officers, if they report that information, could be on the hook themselves. It's not ideal. And so this is yet another reason why we might want and might, as a matter of course, require beneficial owners to obtain FinCEN identifiers so that we, as the people who are in charge of the company, know that we're reporting accurate information. If you're not exempt from filing, there are some serious risks if you do not report your information. I should know, I didn't mention there are a couple of exemptions from who counts as a beneficial owner. Minors, people who are under the age of 18, if one of their parents doesn't reports their identifying information, the minor doesn't have to report. We want to keep their information private until they turn 18 or whatever's the age of majority in their state. And when that happens, the clock starts ticking. On your 18th birthday, if you are a beneficial owner of a company, you've got 30 days from when you turn 18 or whatever your age of majority is in your state to file an updated report. Employees who only have control as employees they don't have to, they typically will not have to report, even though that can be a little bit blurry on some close cases. Agents, someone acting on another's behalf purely as an agent, or intermediary or custodian, that person does not need to file. I think I had to look up, how close does the law of trust intersect with the law of agency to really understand this? And the answer is, to the extent trustees are empowered to say no at some point to the people who've appointed them, it's really a distinction. And FinCEN concretely believes that trustees are going to have to report and will not be covered by the agent exception. But perhaps under a general durable power of attorney, it would be very clear that you're acting on someone else's behalf. People who execute general durable power of attorney forms, their agents should not need to apply. Inheritors, people who only have an interest through a right of inheritance, are also not going to be required to report. FinCEN has told us in some of the materials that they've shared that they expect that this clock is going to start running from the date an estate is settled. That may vary somewhat from state to state, but that is at least one of the mechanisms that's going to make this at least doable. I know we can't get death certificates in Alaska in less than 30 days, so there's truly no way to know who's going to get assets yet. It makes more sense to do it from the date that the estate settles, and it's something that you can set up your firm processes to prepare for. Don't close the estate if you're hired to do that work unless and until you know who your beneficial owners are going to be and you've got their information. The penalties here are not fun. It's up to $500 per violation per day as a civil penalty that has no limit on it, and criminal penalties of up to $10,000 and 2 years in prison, or both. This is a felony. Question whether this is actually going to be applied strictly against everyone who makes a violation, or whether it's going to be sort of an Al Capone type law where FinCEN knows they've got bad people doing bad things, but this is the technical hook they've got to charge them with a felony. I can't advise clients on that, right? They're either breaking the law or they're not breaking the law. So, this is a question for exactly how much enforcement we're going to see. Those are what the rules are. That's what you should tell your clients. And this covers anyone who directly or indirectly gives false or fraudulent information to FinCEN. They are really strict about this. They generally find that people who inadvertently file false information, who've got a good faith belief after conducting due diligence or a diligent inquiry, is likely going to be not going to be deemed to have willfully failed to report complete or updated beneficial ownership information. But frankly, I don't want to have to find out. I'd like my clients to certify they're giving me correct information and maybe just confirm that the address they've given me on file is the address that they're asking me to report to FinCEN. I've got a diagram here of a fairly standard estate plan, and this is this is a totally common way for a family to organize its affairs. You've got a husband and wife who've got a revocable trust that has trustees. It might be them during their lifetime incapacity, but if they're old and starting to lose their capacity, we might have a co-trustee who's a trusted advisor or a family member. They may also have a trust protector who's involved on that trust. I seldom prepare any document that doesn't have a trust protector. Even a will that will likely not create a trust, I still like to have trust protectors involved whenever there's a possibility of a trust being created. The family LLC, it might own that family LLC entirely. So a holding company that's managed by a son or a trusted child, because they're trying to pass control over the family business over time, and they want to sort of educate their child on how the business operates. And they've got some subsidiary entities. So these are a couple of just different ways that we could end up with a lot of complexity here. We've got, the family cabin property, a half ownership interest in an office building. We've got, an Airbnb. We've got a widget maker that they own 30% of. Their daughter's in charge of. Well, who are the beneficial owners here, right? I think, it's not controversial to say that husband and wife are beneficial owners because all of the ownership interest ultimately flows up to them. They are the people who own it, and FinCEN really wants to find the natural persons behind the entity. And so husband and wife report. Any other trustees who are then serving can report. It's kind of an open question whether someone who has the authority to remove a trustee should be treated as a beneficial owner. trust protectors who have the authority to appoint and remove trustees. I think there's a very clear argument from FinCEN's perspective that these people might need to be reporting people. I also think that, if a successor trustee has the authority to boot out a currently serving trustee, and that authority is, it does not require the determination of an adverse party, that they might also be deemed to be controlling persons. That the family LLC, the son's in charge of that. The son is a reporting person for the family LLC because he controls its day-to-day operations and its business. He's in charge of it. He's analogous to a CEO. What about some of those other subsidiary entities, right? The family cabin and the Airbnb are wholly owned, so they should likely be exempt as wholly owned subsidiaries of a reporting company. The office building that the family owns a 50% interest in, well, that's not subject to the exemption. Whoever's in charge of that will need to get the information on the beneficial owners here: husband, wife, any other trustees, trust protector likely, the son who manages the family LLC, and then report that information to FinCEN or be in trouble. Similarly, the corporation that the daughter runs, well, it's not wholly owned by a reporting company. So it may have to report. We'll need to ask at that point, does that company have more than 20 employees? Does it have more than $5 million in receipts for the last business year? And is it otherwise exempt? Does some other rule apply to it? For a company that makes widgets, probably not. So those are the types of considerations that we're going to have to walk through. That's a really sort of quick, dirty analysis of that. And I'd be happy to talk through specifics with anyone at some point, because truly this is going to depend a lot on what your trust documents say. I think there are a couple of steps. I mean, really, the most interesting thing here and the most important thing here is to start thinking about planning. What steps can we as trusted advisors give to people or to our clients to help them prepare for what the CTA is going to require of them? I think notice to clients is essential. We have given 2 letters to our clients already, and we're giving more out next year that are simply going to tell them what the CTA is and why it matters for them. I will say we always know that all of our clients always read everything we send them, and they always understand it perfectly, and they always listen to us. My faith in that has been rattled this year because I've been getting phone calls from people who read these letters and say, "Yeah, but the Corporate Transparency Act doesn't apply to me. I'm just a dentist." Where's the dentist exception? There isn't one. I'm just a landlord. There's no exception for that. People need to be sort of beaten over the head with this, in my experience, so they actually recognize that they've got to do something, and they might not like what they have to do. This is also a good time to update forms and business processes to make sure. Oh, sorry, I skipped around. Just to make sure that you have every process in place so that you, as a company that creates entities, gets the information you need when you need it. And also deciding whether your firm is going to file beneficial ownership information or BOI reports. Because I've talked to some practitioners at small law firms who are unwilling to do so. They simply don't have the capacity. The people who are solo practitioners might say, "I don't want this risk. I don't want the time it's going to take. I'm going to make this someone else's problem." Decide whether you'll file updated reports for people. 30 days is not a very long time to get information from clients. So in general, think through who and when you might file these reports for. And then also create processes for collecting client information because they're going to need to give information to you at some point likely. And then also understanding estate planning documents well enough so that you can quickly identify beneficial owners. I know we've started working on internal memorandums to identify within our documents what clauses might trigger a person to become a beneficial owner and under what circumstances, so that we can move very quickly to identify these for clients and not have to bill them time they don't want to pay us for. All right. Typically, I like to tell clients in my letters what the CTA is, what they need to report, who needs to report what the consequences of non-compliance are. Most of my clients are very scrupulous, good business people. Some of them are relatively simple, they're employees, they collect a wage, they're not very sophisticated, but they created an LLC at some point to own a rental property. They don't want to break the law, so we want to tell them what their obligations are. And we also want to make clear in our letters too, are we going to file reports for you? The answer is no. You got to give us the information first. But they need to hear that so that they don't think that you're taking care of this for them without them hiring you to do the job. I have tried to send scarier letters to clients, and it's starting to get through to them. But this is also a way that before we have any real tax, we don't have any clarity on what's going to happen in Congress at the end of next year. This is a reason to get clients into the office to start looking at their documents, start fixing their documents to help them be compliant. And this is, I think, a good reason to send these letters out to clients anyway. I think it's good for business development. So forms that we use internally that we want to make sure are better are intake forms. We need to ask questions. We already do ask questions about ownership interests, but we're trying to make them impress this information on people better. We've created separate beneficial ownership information worksheets whenever we have entity formation clients, so that we've got all the information we need in one place. Engagement agreements are spelling out who's going to be responsible for filing these reports. If we're creating the entity, if we control when the clock starts running, then I feel pretty confident that we can and should file those initial reports because we know when the reporting requirement starts. We will even condition forming entities on getting all that information first because we don't want to be in trouble for not filing that paperwork. Sometimes clients will say, no, I'll do it myself, and that's fine. We're going to get it in writing. And then, there might be a handful of circumstances where we'll file updated reports. But there are a lot of variables. I won't name a road I won't walk down, but that one is going to be a tricky lift for our firm and for, I think, most firms. Similarly, for estate planning documents that create trusts, identifying who can be a beneficial owner really matters. There are a lot of powers in trusts that might be deemed to create beneficial ownership. I don't want to walk through all of those possibilities because there's a lot of inventiveness in the estate planning community. But I would say, powers of appointment, things that allow a person to appoint assets from one person to another. FinCEN is going to see that and think, gee, they can change who owns this property. If there's a presently exercisable power, I think it's a good argument that that person needs to report. Swap powers, the ability to demand distributions from a trust. If someone who's the only permissible recipient of trust income or principal, so after a trust becomes irrevocable, like a Q-tip trust, a surviving spouse is probably going to be a beneficial owner, even though it's irrevocable at that point. Crummy powers may create ownership problems in some cases. So, for instance, I normally would include crummy powers in some trusts to cause estate tax inclusion for beneficiary or gift tax inclusion for beneficiaries. We don't have to pay gift tax when the initial transfer occurs. But my concern there is that at a certain point they no longer have the ability to withdraw significant or substantially all assets of the trust. I don't know where that line is. And sorry if I'm talking a little loosely. I didn't have good notes on crummy powers here, but I know they're going to be concerned. There are likely many other types of powers that may cause inclusion. We may want to reevaluate who we recommend to serve as trust protectors. We might be less inclined to name family members or trusted, sort of friends, and more likely to name institutional parties to serve as trust protectors, like trust companies or law firms. Operating agreements and bylaws. This is also a good time to make clear who at the company needs to collect what information, who's got to provide what information and how. I think requiring people identified as beneficial owners and identifying explicitly beneficial owners at the outset who might become one is a good way to make clear that anyone associated with a reporting company or a company, whether or not it is a reporting company in any given year, has to give the information. This is a way to insulate our clients from trouble and help protect them. We also, in any documents that might change beneficial ownership, buy-sell agreements, purchase and sale agreements, employment contracts, we need to address CTA issues in these documents and update them if need be. And then for things like probates and postmortem trust administrations, clients need to recognize this is something coming down the pike. We've included this in the letters that we make available to people who are grieving, who have not yet started the process, or who recognize that a family member is ailing and they want to get their ducks in a row now. We want them to know that they have to identify all of the decedent or soon-to-be decedent's business interests and understand whether they're going to be reporting obligations there. And so, in general, this area is, I don't I imagine it's going to be especially complicated for everyone, but it's another thing that has to be incorporated into internal processes so that it's done correctly. There might be some state variation on when an estate is deemed to be settled. And I know UPC states might do it one way, other states might do it another way. But this is an area that you're going to need to answer for yourself based on your own state law. And then filing reports, we might file reports for some people and not others, and sort of thinking through what makes sense for your law firm. I would be wary of being hired to evaluate a relationship where multiple trusts own business interests. And those trusts are subject to the laws of multiple states. They've been drafted by other law firms, so I don't know what trapdoors are hidden in them or all of the drafting nuances of them. I might take that in some cases where we've got some lead time and we know before they want to make the change, but they haven't made the change yet, because that gives me the time to identify who the beneficial owner is. Could I write an opinion letter at this point in time on the Corporate Transparency Act? I'm not sure that we have enough clarity in most cases to do that appropriately. So this may be cost prohibitive for some clients. It may be difficult for smaller offices to do at all. So we've also changed some of our processes. Whenever we're creating entities, we try to collect beneficial ownership information. Obviously, I want my clients to get FinCEN identifiers for themselves if they can, and I'll accept that information instead of all of their other paperwork. Otherwise, I'm going to need a photocopy of a current ID. I'm going to need them to give me the information I need before I form anything. And this is going to be a sensitive area for clients. It's a new thing for them. They're going to be worried about it. I think it's appropriate to be concerned about asking people to send this type of information electronically. Sending it through a share file type service may be better. Having clients do it in person is probably the safest of all these ways, but this is one of the many areas where we could get into hot water if clients are simply sending easily hackable emails to us that contain all of this important info. Beneficial owners may be unable to provide information in person. They might live in another state. In Alaska, living in another state is a pretty big deal, and it comes up a lot when we've got people who are elsewhere. So that's something that we're also concerned about getting. It's another reason that people might want to get their own FinCEN identifiers and maintain that information for themselves. And then, yeah, I've said we're already doing this ourselves. You may consider just having sort of internal cheat sheets for quickly and easily identifying beneficial owners. I think right now, with pretty slender guidance from FinCEN for estate planners, we may end up over-including beneficial owners. According to the literal terms of the statute, over-inclusion would be an inaccurate filing and will be problematic. They might say that you breached your duties, you filed a bad report because you've included people who shouldn't be on there in the first place. So identifying who the beneficial owners are is a good way to do that. Now, is that consistent with what the law is really trying to accomplish? FinCEN seems to think so. They want good, clean, accurate information. They don't want a bunch of chaff in there that is not going to help them. So that's a concern that I hope does not get litigated. I hope that we get very clean answers on in the near future. I also think that a lot of firms are going to think about the economics behind beneficial ownership reporting. These might, I'm planning on doing these reports hourly at first, and then as part of a flat fee, as part of either entity formation or as a separate flat fee on top of the entity formation, because ultimately most of these for most LLCs will be pretty simple, but when there is trust ownership involved, it's going to get complicated. And so that's probably going to be a heavier lift. If I've prepared the estate planning documents, I'm more comfortable with them, and I can identify readily who's involved. I might be happy to charge for that. I might be happier to charge a flat fee for that. But for complex structures, I don't know when we'd ever be able to do a flat fee, because that could be a very difficult thing to do over and over again. And then having streamlined processes for information collection for initial formation and giving clients the confidence that they can comply with the CTA is going to be very important. The alternatives to the Corporate Transparency Act reporting requirements, I don't like these alternatives, but some people may very well end up choosing them either to maintain their privacy or because they're just very concerned that they won't be able to comply in the future. So obviously clients can file their own beneficial ownership information reports. They can be self-insured, which is to say, you know what, if the rental house, catches fire, then I'm going to be exposed to that. And they can obtain insurance instead of doing entity-based planning, right? I worry about insurance because, I don't want I don't want my clients to end up in litigation. I don't want them to be stuck in a place where they are going to have sort of surprise exclusions or things that they thought were covered that aren't covered. And it's the ongoing expense of insuring property that's used for business purposes. Insurance is an option here. I don't love it as an option, but I think some clients are going to choose that or self-insurance instead of Corporate Transparency Act applying. I think that we're going a couple places. We might see legislative changes. I don't know that this is I assume this law will be very unpopular with 32 million or so companies that are going to be required to report. And a lot of the people who own entities in the U.S. are people who can make outsized contributions to their political representatives. They may have the ear of people who control things. I will say this was sort of a surprise to a handful of elected representatives. They voted for this. They don't really understand the issue yet because they're hearing it from the law enforcement side, from FinCEN's side. We've considered including by the way, feel free to contact your elected representatives on the letters that we have that we've sent out to our clients. We've decided against that in most cases, but that is one of the issues. If, on the other hand, the CTA might lead to more reporting requirements, there are other acts that have been bandied around. It might encourage Congress to continue with other anti-money laundering rules. It also might deter future legislative misadventures later if this it proves to be very unpopular. We'll also note FinCEN only has about 300 employees and a fairly limited budget. It remains to be seen just how capable they are of enforcing the CTA without outside help. They might come to have those practices in place, but they may not be able to. Specialized firms may come to enter the CTA reporting space. Would that be a bad thing for most of us? I don't know. I'm also sort of skeptical that you can have sort of one size fits all firms that can handle this type of work for a lot of different states. And I think it's also possible that clients might avoid LLC planning in favor of insurance. That's everything I have here. I know we've got a lot of questions that I've been saving for the end. I have not looked through. So I guess Jamie or Barbara, can you help us kind of get through some of those questions?
Yeah, certainly. Thanks, Chris. That was a lot of really good information. So thank you so much. We do have a number of questions, so I'm going to quickly get to them because we have about 8 minutes left. So starting off, let's see here. So when multiple beneficiaries of fully discretionary trusts over which beneficiaries have no fiduciary role or powers, do they have beneficial ownership requiring reporting?
So in the circumstance where we have discretionary inheritance trusts that have multiple owners or multiple beneficiaries, the idea there is it's difficult to say that any one of those beneficiaries, suppose we have a pot type trust where we've got multiple permissible beneficiaries. I think it's very difficult to say that any one of those beneficiaries is entitled to the money from that trust or the proceeds of that trust. And so in those types of circumstances, what we've heard and what FinCEN has told us is that if you are the sole permissible beneficiary of income and principal currently, then you are a reporting person. If there are multiple beneficiaries, then I have interpreted their silence on that to say, well, probably not. And it makes sense that you wouldn't be. We still have to know who the trustee is, but once the interest shifts, then there'll be a reporting update. So if I liquidate, LLC to one beneficiary and cash to another, then that beneficiary, that transfer will trigger a reporting requirement. I would assume that those multiple beneficiary trusts would not have to report beneficiary depletion.
Okay, thank you. So there's a couple questions that are really pertaining to ownership and provide some percentages, but one question is an individual has a beneficial interest of 60% in an LLC but is not manager. Does this individual have to file?
Yes, they do, because they have 25% or more ownership interest. And I will say, You can have people who are beneficial owners over the same number of interests, right? So even though we might only be able to have four people who can have 25% ownership, we can have well more than four beneficial owners.
Okay. Let's see. Ooh, there's a number of very long questions. We might have to get to those after the webinar. So let me see. Apologize.
So I see a couple here that I'd like to answer pretty quick. I
Okay.
see someone has asked, do single member LLCs need to report? Yes, they do. It has no real relationship to the economics or the tax burdens they have. It's just they've created an LLC and they're in charge of it. Sorry. Um, and then let's see, we've got a few others in here that look good. So if you see any that you want to answer really quick, please throw them out for me.
Um,
Do the trustees of a grantor trust have to file? If the trust does not own ownership interests in an entity, then they don't have to file. There's nothing. They're not a reporting company. They don't have beneficial ownership. But if the trust owns an interest in a business, then yes, the trustees of a grantor trust will have to file. Now, when we use a trifurcated type model and we have administrative trustees in addition to, say, investment advisory trustees or distribution trustees, the admin trustee will very likely not be a beneficial owner and won't have to report. But the investment trustees and the distribution trustees probably will look at your documents to confirm.
okay. So knowing that, LLCs, we're working with LLCs, does it matter what type of assets are owned by the LLC, or it's simply just the fact that the LLC has been formed in general?
Generally, the assets held by the LLC do not matter. The only case where I can think of that the mattering might be in circumstances where what the business that the LLC is in otherwise qualifies for an exemption. So if the LLC is an accounting firm that is subject to Sarbanes-Oxley, then the LLC will be exempt from reporting. If the LLC is a large operating business, then it's exempt from reporting. But otherwise, no, what's in the LLC shouldn't matter.
So, Chris, you and I have discussed, some current litigation that's challenging CTA. Is there, what sort of traction does any lawsuit have against CTA?
This is a pathway that has been used for a while to go after sort of corporate to I'm this is an area where we have long been solicitous of the federal government in terms of being able to collect this information. I don't know too much about the underlying litigation challenging it, but I'm not going to really be able to plan around that unless and until I get clarity. For now, this is the law of the land, and I'm going to try to comply with it to the best of my ability.
Okay. All right. Let's see. What about one last question? Any opinion on applications of attribution rules?
Uh, how do we mean by that?
Okay, let's choose a different one. Another short one. Let's see. Does FinCEN have an information sheet we can send to clients?
So FinCEN's materials, I've been a little bit disappointed with. You can check their website. They've got a number of materials. Some of the short ones simply restate the rule in very vanilla terms. They also have a small entity compliance form or small entity compliance guide that has a lot of more useful information in that. That's pretty long. It's not binding, but I think it's a very clear sense of what FinCEN is going to care about.
Okay. Let's see. We have one last minute. So I guess we can go ahead and wrap it up. It's been a very informative hour. So thank you so much, Chris. I really appreciate it. So for everyone that has joined us, please reach out. Our contact information is here on the screen. And then we will also be following up with some answers to your questions. And then just a reminder, this webinar has been recorded, so you will receive the recording after we end our webinar today. So thank you so much for attending. We really appreciate your time. And Chris, thank you so much for letting us pick your brain as well as you sharing all of this information. It's been amazing. So thank you so much.
Thank you, Jamie, and thank you everyone for taking the time to listen to me. I really appreciate it.
Thank you. Have a great day, everyone.